Welcome to Opinions My Own. My name is Paul Caulfield. Today's guest is Sherman Deng, a friend and peer of mine who will be joining us from Shanghai, China. Coincidentally, as the geopolitical tensions increase, as the tariffs tit for tat increase, we've had this scheduled for some time now, and our conversation stays out of the geopolitical fight that's occurring and really discusses how does one operate within China as a multinational, as a Chinese company, what are they doing in considering working within the United States? We talk about Sherman's transition from Marriott International, his education within the United States, and now practicing law at Fangda Partners. So please enjoy this episode with Sherman Deng, Fangda Partners. Sherman, it's great to see you. Thanks so much for joining me. So we already have kind of previewed what we're going to talk about. I usually don't I usually don't talk about someone's background because I kind of post it and the listener has an opportunity to read about it. But welcome. I'm really pleased that you're joining us. Let's start with your history. You and I came to know each other back in 2022. We've met both in Shanghai on mainland, as well as in the United States in New York. We'll get into that, but let's start with you. Tell me a little bit about yourself. You're right now speaking with me from Shanghai.
Yeah. So thank you, Paul. First, thank you for inviting me. It's always a pleasure to talk to you again. Yeah, just a little bit a little bit on my background. Now I'm a partner at Fangda Partner, which is a local law firm here in Shanghai. But before Fangda, I was educated in the United States for my law school. I had my LLM. It used to be the Master of Law, but now it's for a different meaning at UC Berkeley. And then I practiced in New York for 2 years before moving back to Shanghai. I was with an international law firm, Y&Ks. And then I moved to work in-house at Marriott for 7 years at their Shanghai office. That's when I switched from a deal attorney to a compliance slash data privacy attorney at Marriott. So it was in 2022, I moved back to private practice. And then pretty soon I get to know you, Paul. And then it's a wonderful journey that we had together.
No, it's been nice getting to know you, Fangda. One of the things I enjoyed learning about with Fangda is it's one of the elite law firms in China. China has this term, the red circle firms. It's the elite. Kind of sounds pretty cool. The UK has their term is
Magic
magic
circle, right?
magic circle, right?
Yeah.
Freshfields, Linklaters. The US, all we call the big law firms are big law. It's
Right, big law, white shoe, right? White shoe.
it's not as creative, but the red circle, yeah, you definitely have um, the experiences. Before we talk about your work in Shanghai at Fangda, can you talk a little bit about your experience working with Marriott as a multinational, as a U.S. Incorporated firm that was operating not just globally but within China? You don't need to talk about anything
Mhm.
that's sensitive,
Right.
obviously.
Yeah,
But
yeah,
tell me about your work with Marriott.
yeah. I think my work with Marriott is the same with many international companies operating in China. So you always have a corporate headquarters to report back to, because all these business are kind of centrally managed. So you have your global compliance program, but on the other hand, you have to respect local legal requirements.
Well, let me
You
ask you
have to
this.
do.
At the time that you were at Marriott, I mean, here we are, the geopolitical tensions are kind of unprecedented.
Mhm,
We might not have been this way for, 50 some odd years.
mhm,
We've got tariffs, the trade war. What was it like
mhm,
geopolitically between China and the US at the time you were working with Marriott?
mhm. Yeah, back then it was okay. I think I started at Marriott 2015. Um, in their Shanghai office. Um, Back then, the Chinese real estate market was super hot, and there were many projects waiting for an international hotel brand to develop. And actually, it's very welcomed by the Chinese government. The reason being, for real estate, because a little bit background knowledge, Marriott doesn't own any real estate property in China or in the United States. It's just an operator with its own brand. So the logic in China was when those owners or real estate developers, they want to bid for a piece of land, the government will always want to have a five-star hotel to be developed in the future because it's a signature of the local government and it's a sign that all when the foreign executives travel and stay at that city, they can stay at Marriott or they can stay at Hilton. So it's great attraction. So as part of the commitment from the real estate developers, they kind of say, hey, okay, I'm going to build a Marriott after I develop this land. So you kind of get your letter of intent well before you can bid for the land. So I think it was a win-win situation. There was a great synergy. But I think still there's still a lot of synergy today. I think for Marriott and many other international companies, they are doing very well in China. Probably not for the five-star hotels, but now for kind of economy or mid-tier hotels, because the system, the way of operation, there's still a long way for the Chinese hotel operator and the manager to learn from international brands, particularly US brands.
As you started, what made you leave Marriott and go to Fangda?
Yeah, so I think at Marriott, I had a transition from a deal lawyer to a data lawyer for various reasons. One is that at Marriott, there was a great embrace of the Chinese e-commerce landscape. So we had a joint venture with Alibaba, and I worked on that deal. So I started to get to know about target marketing, data and analytics, right? And so that's when I started to get to know data. And then there were many data compliance work that I was put on. So I started to work on data compliance, and I've been monitoring the China's cross-border data transfer regime and watch that grow. Then I thought, okay, such a priority at Marriott, it must be a priority at other multinational companies. So there is this huge business demand. So I decided to leave Marriott, move to private practice, and service this demand, and turned out to be right. So I was able to ride the tide.
From my experience, I started to get involved in cybersecurity. I was in banking compliance and risk. In 2017, our New York State Department of Financial Services passes, I think it's one of the seminal regulations that was around cybersecurity that required banks to have
Right.
much improved cyber and information system security.
Yeah.
Around I find it interesting that globally that was the trend around that time. You and I didn't know each other, but as you moved into Fangda and you started to work with clients both domestically and internationally, what were you seeing from a cyber or an information security trend?
Yeah, I think there have been a lot of things happening, and I think a lot of times we are really the bridge to different cultures. So in terms of cybersecurity, I think most of the work we did was about data breach at Fangda. So I think under the U.S. law, if you are a listed company, or if you are subject to GLBA or other federal regulations, you always have this obligation to report to the authority after you have done your forensics. So you learned that there is an incident, and you have to report, and also you have to notify the individuals if their data turns out to be compromised. I
There
think we
was
have
so
the
there was the U.S. requirements, both
right,
state as well as federal. There were
exactly.
also notification requirements in China.
Right, we have the same thing. We have the same thing. Notification and reporting obligations. But I think I think there's a huge difference in the sense that in the U.S. It's harm based. So you notify the individuals only if there is harm, right? Most of the states don't require you to notify the individuals if it turns out to be no harm. For example, in California, if it's encrypted and there's no way the hackers can decrypt the data, then you don't have to do the notification.
It's
But
not that cut and dried. If
mhm,
there's a breach, I think it's not it's not necessarily a harm
mhm,
definition. It really is there a level of PII, personal identifying
mhm,
information, that has been disclosed? And then
mhm.
regardless of harm or not, this is, I get your point, but
Yeah.
I think from more of like a fact pattern standpoint,
Mhm.
giving notice to the consumer so they can do um, uh, so credit monitoring, fraud
Right, right.
monitoring can be put in place. But what's
Yeah.
the standard in China?
Yeah, in China, it's a kind of a compromise. So the law really reads, if you have a data breach, you have to notify the individuals, unless you have determined after reasonable means there is no harm. However, if the government believes otherwise, if the government thinks there is harm, then you still have to notify the individuals. So that's what's in the law about notification. And then there's in the law about the reporting obligation. The reporting obligation is almost absolute. So if there is a breach, it doesn't even have this verification or forensic procedure or root cause analysis. As long as there is a breach, you have to notify the government within 24 hours. So as you can see, the government is really playing a heavy hand here. So basically, you have all the companies have an absolute obligation to notify the government, and then it's for the government to decide whether you should notify the individuals. But that's a law on the book.
If we, I want to compare US and China. If there was a breach, and I'll speak kind of broad regulatory, whether it's a bank, hospital, education. If there's a breach and there's a reporting requirement, yes, you move through the reporting of the affected parties, notifying law enforcement, notifying your regulators. But then there is a root cause where the regulator would expect to understand what was the nature of your program before the breach. And that
Mhm,
starts
mhm.
from, board liability all the way down to
Right.
the technical controls that were in place. And if you did not have the proper controls in place, that opened up a whole different set of liabilities. How does the root cause look like from a PRC standpoint once the notification happens? I mean, you use the term heavy-handed, and I'm not
Mhm.
sure if that was tied to liabilities or accountability, but can you speak on that?
Right, right. So I think in China we also have this expectation of governance, the data security governance at the company. In particular, we require an incident response plan or IRP that a company should follow when they notify the government of an incident. So before you go ahead and report, you are supposed to complete your root cause analysis to make sure that it's not false positive. Because incidents can happen every minute of every day, but most of them turn out to be false positive or is already prevented. So it's only after you took reasonable measures to complete your analysis, then you notify the government. But that's not really in the law. The law doesn't say anything about root cause analysis. The law just say if you learn of an incident, you have to report. But then it's down to the companies to have their IRP. Let's say if in the IRP there is a root cause analysis procedure, and for a team to verify, okay, there is an incident. before you do your notification, then the government will buy into that. They will respect all these procedures that you put into the IRP. However, on the other hand, as you mentioned, Paul, if the company has no IRP at all, the absence of an IRP itself is a kind of a wrongdoing that will subject the company to liabilities. So then to the liabilities, indeed, for basic compliance work, if you have your IRP, have your compliance procedures, had your trainings before, invested in cybersecurity, and those are all kind of sort of exculpatory evidence that you can present to the authority to mitigate your liabilities.
Tell me about, we're gonna focus specifically on operating within China right now. What is going on, particularly over the last few years? Let's start with the Great Firewall. Explain what the Great Firewall is.
Right. The Great Firewall, I think it's there's a lot of legislations around that. But basically, for platforms that are content heavy, they are required to have their servers in China, and China really has this sort of a censorship procedure and all these technical means. So if you are content heavy, you don't have a server in China, and then this Great Firewall can kind of block it. And also if there is there are things that's really harmful to China's cyber sovereignty, then the authority have the right to block those foreign websites. But I think a lot of the foreign sites are still available, but only those I think on a blacklist they get blocked. So some famous sites, for example, Google, Facebook, they are not available in China. I don't have a track record of what's available and what's not, but I think if you travel to China, that's an obvious thing.
When I first went to Shanghai and met you in the summer of 22, I had my phone and it was basically useless. I mean, once I entered mainland, there was no Uber, there was no Facebook, it really became a brick. And I remember going to my hotel and going to the concierge and asking them to get me a taxi because I didn't have the apps on my phone. And it truly was. When people asked, what did you think of your trips to China? You know, I was able to talk about the food. I was able to talk about the people, the incredible commerce. But I also said, forget it if you think that you're going to operate your phone like you do, you know, outside of China. Tell me a little bit about that, and how do you know, how can visitors, how can people enter China, enter mainland, and be a little bit more functional than me with a brick in my hand?
Right. It's really a pain in the neck. So yeah, I feel sorry about
Wait,
that.
do you experience that too?
Not at all, because when I travel to the US, basically I can get my Uber and get my basically get everything. It's pretty easy to get around. But I think for visitors to China, I think there are two folds of reasons why they cannot get around as easily as in their home country. One, of course, has to do with the Great Firewall. But however, if you are using your data plan in the US, let's say you are not connected to the local Wi-Fi's, you can still be able to have Facebook and Google. It's just that you have to pay more for the traffic, right? But on the other hand, the other reason is, Uber quit China many years ago. So it was acquired by another company. It's called Didi. And then shortly after the acquisition, it was the great pandemic. So we were basically in a lockdown for 3 years. And in those 3 years, I don't believe many expats traveled into China because of the quarantine procedures. So basically, China has grown its local ecosystem in terms of these apps, the travel and entertainment apps, and it's all in Chinese. So now, after reopening in 2023, a lot of foreigners reported this inconvenience to the Chinese authorities. But I think now it's getting way better. So I think if you come to China at the airport, you can at the customs, you can find there are many QR codes for you to download all kinds of apps. Besides, in China we almost no longer use cash, so everything is online, and the credit card is not widely accepted. So basically, you always have to use, let's say, Alipay or WeChat Pay. So then I think at the airport, you can download an English version of Didi. I don't believe it can be used as a standalone app, but in any case, you can use it as a part of your WeChat. And also you can download the Alipay. And once you have the Alipay, you can connect to your credit card. Then you can make payment. And I think the other thing you can do, of course, is you can download a VPN program or application before you travel to China. Then your apps outside China can
Well,
work seamlessly.
let's talk about that a little bit, and
Yeah.
I'll turn it on the U.S.
Mhm.
for a second. The
Mhm.
EU just issued either it wasn't a directive, but a warning for anyone in an official
Travel
capacity
to
coming to
US,
the
right?
US
Yeah.
should have they called it a burner phone
Right.
and not enter the US with sensitive government data on their phones.
Mhm.
Now, that's been a long-standing method of operation going into China. The presumption being that if you go into China with your phone, with your computer, with your tablet, that there is zero presumption of privacy controls, that Big Brother, as Orwell wrote, is in fact listening.
Yeah, I think for the EU one, it's more about national security. Of course, national security and the privacy, they are tied together. So I think it's really about the sort of losing of trust between EU and the US in terms of these government officials. Their sensitive data about the government maybe espionaged when they are traveling in the US. I think for China, it's the same reason. So I think there's a policy called the zero trust policy, maintained by many companies that they believe if their executives travel in China, the proprietary information about their company can be espionaged by their competitors. Let's say they can hack into the hotel Wi-Fi and steal them from their phone or steal them from their laptop. So the policy, I think it's called the burner phone and the lone laptop, right? I think it's been going on for a while. But I think in terms of privacy and hacking, it can happen anywhere, right? So not just in China. If you travel to other countries, there's always the risk of hacking. So yeah, I think it just has to do with company policy, but I don't believe any individual traveling on their individual capacity will want to give up their iPhone and turn it into a burner phone because it's so much inconvenient.
Yeah. Well, so when you and I started working together, the anti-espionage law had been amended and updated. The GDPR equivalent PIPL had just been issued in I think October, November of 2021. And what you and I started to see is, and the term that we're using was hiving off. The law firm Denton's started to really separate and segregate its China mainland based practice. Sequoia, the investment house, they started to, I think, completely separate, not just for mainland China, but for India as well as
Right.
APAC. So as these companies are completely segregating and localizing their operations, in many cases they've separated the books and records. There's
Mm-hmm.
no sharing of revenue, and they're localizing it. Is that the only strategy to operate safely, securely, uh, commercially in China if you're a multinational?
Yeah, I think there are many reasons for them to carry out this strategic restructuring. But as you mentioned, I think data security certainly is one of the reasons behind it. Um, so I think so let's talk about data security. I think the sort of quote unquote decoupling is not one way. I think it's two ways, right? I think one on the one hand is because when back when you and I were working together, there were a lot of cross-border transfer and data localization requirements. It become increasingly hard for data to leave China because you have to go through these security assessment procedures, SEC procedures. Back then, the rules were crazy. If you have one piece of personal information leaving China, you have to complete your SEC filing. I think back then the authorities were overwhelmed with these SEC filing applications. But then the rule really got relaxed. And because it's really a regulatory overkill. So now we have all this bulk threshold under which you don't have to do anything. You only need to do record keeping at your company, but you don't have a preemptive obligation to file. So now we see that increasingly relaxed. However, on the other hand, I think in the U.S. in particular, they're ramping up their sort of data cross-border transfer restrictions, like the recent EO 14177, no 14117, right? The name is really long, right? Provisions pertaining to preventing
Yeah, the
access
executive
of
order.
sensitive personal information and
Yeah.
government-related data by countries of concern, right? It's such a mouthful. Yeah. So I think I kind of believe those companies that did the segregation, I think also include some famous law firms like Latham Backins, right? They also did their IT segregation by denying access of their China-based associates to data in the US. I think they kind of get some headwinds about this. So they see the decoupling as a must in terms to maintain their operation and avoid getting into troubles with these data segregation rules. I think that was what's going on.
So to be clear, from my understanding, there are firms that can truly hive off and have independent operations that are going on, and maybe they are strategic partnerships.
Mhm.
I think Peak 15
Yeah.
with Sequoia,
Mhm.
Dacheng with Dentons, where they're completely separate entities, but you've got these
Yeah.
strategic partnerships. And those companies, as they're operating in China, they truly are localized data, localized cybersecurity, et cetera, et cetera, et cetera.
Right.
But I am curious about the blend. Maybe it's a Marriott, maybe there's another example. Apple's probably a great one where they don't have a separate entity. Um, it's a part of the Apple entity globally. But how are
Mhm.
they operating when it's not it's more enmeshed?
Right. Right.
What
Yeah.
are their practices that they can be doing so non-China data, whether it's
Mhm.
intellectual property,
Mhm.
whether it's client information, financials that are irrelevant for the China operations, how does a multinational protect that when they are more of a enmeshed set of operations?
Right, right. I think I can speak about Apple and Tesla based on public information. It's all public. So first of all, they have a huge volume of personal data. in China. There are many iPhone users and Tesla drivers in China. So they kind of meet a criteria for what we call critical infrastructure, because I think they have the volume is around 10 million. I think there's a vague threshold about who should be a critical infrastructure. But for sure, Apple and Tesla, they certainly hit that bulk threshold. So they are required to localize. I think they are under the one brand, but in China, they do have their localized infrastructure. Like Apple, I think, has a cloud server in Guizhou province in southwest China. So all of us Chinese iPhone users have to agree to the terms and conditions that our photos are stored on that cloud. I think same for Tesla. There's been a long push for them to have a data center in China. I think now they do. So that's one part, as you mentioned. But the other part is, of course, on these servers, there can be personal information of their clients and the customers. Then there can also be proprietary data, know-hows, trade secrets, upon which they operate. So I think it's of course they also have a similar copies of data for proprietary information and they're global. Then I think it's about they have their IT security strategy, the level of trust that they give to the individuals. I think following the principles of CIA and AAA, right? Then you give them the authority and keep logs and have the access control. I think it's pretty much the same. So I think then of course in China it's not like the Wild West. We still have trade secret protection. We have the unfair competition laws. So if there are people hacking into these systems and get hold of their proprietary information, they can report to the police. Police will come and investigate, and they can sue people at court. So there are a lot of protection mechanisms that they can take advantage of.
So CIA, the information that it's confidential, that there's an integrity to the information, and that it's readily accessible.
Yeah.
So pulling back, and I don't think it's terribly controversial to think that there's no way that China is going to be completely segregated and the rest of the world or the US is just going to operate without China. The historical manufacturing infrastructure, I mean decades of infrastructure of skilled workforce, even the consumer market, it's unavoidable. There might be a rebalancing, or there is a rebalancing, but as you're seeing clients or prospects or just interested parties come to you, what are you seeing from that rebalancing as clients or prospects are wondering, do I stay in China? Do I even enter China, or do I leave?
Yeah, I think I'm getting questions from both sides. Clients and the prospective asking me if they should stay and grow in China, and clients and prospects, Chinese ones, of course, asking me if they should stay and grow in the US. But I think the answer
let's go with the first, because I think that's you're right.
Right. Yeah. So of course, go with the first. I think first, it depends on your market presence and what's your revenue, what's your market share, in terms of that percentage to your global revenue. So I think those with 10% to 20%, their answer is very clear. They are here to stay. They are gonna stay in China because the market is so important to them that they cannot afford to lose it, right? But those with business less than 5%, they can consider alternative strategies, like hive off a little bit or hedge, right? They can find local partners, do a joint ventures, or even consider spin off. I think the different companies have different strategies, but the big question is, what's the share of your revenue in China? vis-a-vis global. If it's 10 to 20%, then they are here to stay. And the other questions now they ask, okay, if they have 10 to 20%, they're here to stay. But they understand now there's a superpower struggle. The U.S. Of course have done a lot of things, right? They're wreaking a havoc. So they worry that their business in China may be shaky, or there may be government retaliations in China. So they're super worried. They've been asking us to let them know about the legal structure in China that could really come back and hurt them. Because in China, we don't have a law like IEBA, right? The International Economy Emergency Power Act, based on which we have the tariff, the sanction, and export control. But we have something called the Foreign Relations Law, right? So Foreign Relations Law, under the Foreign Relations Law, China can also throw sanctions, export controls, and blocking rules. Right? If there's a sanction or export control measures in the U.S., then China can have all these blocking rules. So yeah, so we have all these toolkits that if there's something really harmful to the national security, then the authority can rely on those legal toolkits to tackle the problems.
So when you and I were working together and the geopolitical tensions were rising, without disclosing corporate names, there was an investigative firm where people were, as I learned the term, asked to have tea with some local law enforcement. There was a global management consulting firm that had also been investigated. There was an expert network firm that was also similarly investigated, as well as had that invite to tea. And so you had those dawn raids that were occurring. You could see what was happening now, not just the reactive tariffs by China. What are you seeing the PRC do in addition to the tariffs with what's going on locally for companies that are operating? Are you seeing anything or catching wind of anything?
Right. So look, we have two balls on the table. One part is the tariff barriers. That's obvious on the table. The other, I think, is what we call the non-tariff barriers, right? That's under the table, but it can still hurt. I think back then, what we witnessed in 2023 is part of those non-tariff barriers, or let's say blocking rules. But because I think back then, it was a Biden administration, right? And there was a lot of sanctions and export controls thrown at China on semiconductor chips and other high techs. So I think back then it was the Chinese authorities were wondering, oh, how come the U.S. intelligence community know about those critical technologies that China depends on the U.S. for? So that they can throw surgically targeted export controls on those technologies. I think back then those firms, whether expert network firms or consulting firms, one way or another, they fumbled the wrong stone and become part of the supply chain of that kind of sensitive information. That now has a legal term, as you're already familiar with. It's called important data. That's data already sensitive enough to national security, but not yet becoming classified information. So I think back then, those guys were caught on the hook for passing on potential important data.
Yeah,
But now I think, yeah.
it was semiconductors,
Uh-huh.
it was electric vehicles, it was even like economic data. And as I was working, the way I phrased it for interested parties was, look, if China, if PRC feels like it is losing control of its narrative because some globally systemic firm was able to, let's say a JP Morgan, pure hypothetical, was able to put out a market report that was in conflict with PRC's
Yeah.
economic
Narratives. Yeah.
narrative, there was going to be a potential invitation to tea.
Right. That's right.
How'd you
Because
get that data?
yeah, because you can imagine if some international investment banks put a very negative report on China, then people are gonna start to short the Chinese stocks, the Chinese assets.
Exactly.
It's going to harm the Chinese economy. So yeah.
So looking at the present day, what are
Mhm.
the under the table type of pressures that you're seeing?
Yeah, I think some of them are already on the news, so I can discuss them. I think uh, I think on the one part is some of the big brand U.S. firms are being investigated for anti-competitive behaviors or monopoly. I think Google is one of them. Although Google no longer operates in China, the app is no longer available. I think they still have the Android system, right? So now they are being investigated for a monopoly over Android system. I think the other guy, I think is DuPont, right? DuPont, a chemical company, is also being investigated for potential competition behaviors. Yeah, so I think if you have a huge monopoly position in China, it can be a vulnerability. The other thing I think are about the blocking rules. So over the past few years, China already have many blocking rules. One is I think it's called the anti-sanction law. The other is the recent implementing rules for anti-sanction law. So anti-sanction law was kind of a tiger without teeth because it doesn't have a lot of very detailed enforcement measures. Now with the implementing rule, there are very detailed enforcement measures. I think if you are a global, if you are a U.S. company operating in China, then of course you will comply with all the U.S. Regulations, which always kind of include lots of reporting obligations, whether it's annual reporting or you want to volunteer information to avoid the punishment, or maybe there's whistleblowing. But people have to be mindful that in China we have a law. It's called the data security law, and under Section 36 of that law, if any company provide data generated in China to an authority based outside of China, before you do that, whether in connection with a government investigation or with a court proceeding, then you need to get the Chinese government approval before you can export that data. You see, this is a very broad requirement, but the whole purpose of this blocking statute is to avoid companies operating in China give leads to U.S. authorities for further enforcement. So my point here is that you cannot ostensibly enforce a global compliance program in China. You have to be mindful of these blocking rules to avoid getting on the trouble. So let's say before you export that data, let's say to the U.S. DOJ, you better consult with Chinese attorneys. Okay, whether you should give the Chinese authority a heads up or redact kind of the sensitive information before you let that piece of data outside China.
What I've said to uh, interested parties who have asked is, look, if you're going to operate in China, you're going to have China specific data controls, cyber controls, the certifications if that data is going to cross any borders. But you also need to have your policies, your procedures, your governance written in the native language. And so, whether it's a regulator, if you had that unannounced visit, you can show credibly that you actually have a program that is China specific. And so, even presuming that Big Brother is listening or watching, you're able to show that you are walking the walk and talking the talk,
Mhm.
because the level of scrutiny is so much higher. It's more unpredictable than in the US. In the US, most examinations start with like first day letters or entry letters, or certainly phone calls, or a heads up that something's coming a few weeks down the road, as
Right.
opposed to in the next 30 seconds.
Yeah, I think in the US, of course, you have the Fourth Amendment, right? The rule against unreasonable search and seizures. And you have the five, right? The Fifth Amendment, the rule against self-incrimination. But in China, we have these principles, but they are not so obvious, or maybe they are on the book, but they are not in practice. But you are right, Paul, in the sense that at the end of the day, because a lot of these sort of enforcement and increase come kind of informal, like you are being invited for tea. But at the end of the day, if they want to issue a formal punishment, there are still some checks and balances. Let's say if some situation get really serious, and they want to charge you on espionage, then the law enforcement still have to give the case to the prosecutors, right? And then the prosecutors have to present a case at a hearing with the court. And there are checks and balances. And the value of all these procedures, walk the walk, talk the talk, by having all the policies showing that, let's say you have no intent or access to those sensitive data, are the kind of the exculpatory evidence that can get you off the hook. Because once the enforcement authority have these documents, they know they don't have a case, or it's going to be an uphill battle for them to persuade the prosecutor to press a charge. Then they will drop it, right? So yeah, I think again, we are not the Wild West, right? And although there's a theory of the Big Brother, but it's not like you see him every day. So
Right.
yeah, you still can, all those international corporate governance procedures, they can also help and work in China.
What are you, as China companies are entertaining, entering, remaining, or leaving the US, what are you generally advising?
Yeah, I think now the biggest impact we have is the EO 14117. Although it's been years in the making, but I think it really hurts. I think the reason being we have a lot of because there's a competitive advantage in China to do R&D, to do research and development, whether it's being the algorithm or AI or CRO, clinical research organization, or financial analysis, because we have a lot of engineers, and we already have a great market share. Some of the companies here in China, I think their main market is the US. They're taking advantage of the cost advantage. But then now with the 14117, when this bulk US data can no longer come to China, or the access is denied, they're basically losing their market share. So
But to be clear, this would be Chinese companies that are operating in sensitive type of industries, right? It's not just all Chinese companies operating in the US. It would be the inverse of what you and I were talking about
mm,
in China. If you're doing anything around semiconductors, electric vehicles, I forget, some of the others that were pretty nuclear energy research.
mm.
You might be doing it for commercial purposes, but this was high risk, or is high risk in China. It's similar in the US. It depends on what type of company and industry you're in. Fair?
I think now it's kind of across the board, right? Not just those in sensitive industry, because I think again the 14117 is a little bit of a regulatory overkill, because if you look at their definition of the financial data, right? Financial data is not the GLBA. So let's say hotel stay records, those are considered sensitive financial information, and
All
the
right. So
bulk
let me
threshold
ask
is
you,
really low.
what do you see and I'll go into my comfort zone of what do you think the China banks are doing within the US, the ones that have
Right.
branches here? Do you think that they're
Yeah.
going to close up shop? Do you think they're going to stay pat for the moment?
Yeah. I think for the Chinese banks, because back when I was in the US, most of the clients are the Chinese banks in New York. So I'm very familiar with these guys. Most of them, their form in the US is a branch. So I think a branch for purpose of 14117, they are still considered the US persons, right? So I think the regulation doesn't restrict data transfer between two US persons, right? However, what they do restrict is, let's say the bank has a subsidiary in the US, and that subsidiary has to rely on China infrastructure or backstage support. So they have to transfer those data to China. Then it's going to be a transaction between a US person and a covered person. And then there's a lot of restrictions around that. I think for those banks in the US, they are they're working on compliance to comply with 14117, of course, at a cost. They're going to look at what exemptions are available for them, whether it's a financial transaction or it's a intergroup transaction. And then for those that are not exempted, I think they're most likely it's a restricted transaction, and they are going to work on a compliance program. In any case, it's a cost on doing business in the US.
So we're nearing the end. So generally, a Chinese company is operating in the United States. You are saying stay put or leave.
Uh, of course, it has to be a data-driven and informed decision. So what I'm advising them is that they should start with a threshold analysis by at least understand how much they are relying on the US data, what kind of data they are. And let's say if they comply with 14117 by having those data anonymized, desensitized, and encrypted, whether their product can still work, right? If that product can still work, then they can consider compliance. If the product will no longer work, then they'll probably consider spin off the US business. The other thing is, if the product still work, but the compliance cost is too high, I think under the preamble of that final rule, for a big company, the annual compliance cost is more than 500,000 US dollars. If there's no if you can't pass the cost benefit analysis, then probably you also need to consider spin off. That's why now
So
there's a new business to help this company spin off.
the data-driven decision, the threshold, the cost of compliance, very clear for me. Now flip it. What are you saying to multinationals? Are you telling them to stay put in China or to leave? Or is it the same answer? Is it a data-driven, cost-driven type of analysis?
Yeah, I think because first of all, in China, we don't have anything similar to 14117, at least for now, right? So that's out of the
You don't
consideration.
think the amended anti-espionage laws is akin to the executive order?
Yeah, I think in China we have the law on the book and the law in practice. Um, the law is very strict on the book. Anything can be an important data, but when it comes to enforcement, it's quite sporadic, or let's say enforcement law by choice. Even the authority is saying, because under the law, when you export important data, you must get an approval. But the authority is saying, unless you receive a very specific written notification from us, you don't have to worry about getting this approval. You can do your business BAU. But if you look at the DOJ will always say, I'm very serious about enforcement. That guy, Devin DeBacker, right? Say, hey, we are growing our team. We are going to hire 20 enforcers and we are going to
Pam
work with
Bondi
the
does not
FBI,
talk
right?
like that, I can tell you. Wait, no,
Yeah. Right.
like I want to push you for an answer because the
Yeah.
anti-espionage that came out of that was
Uh,
amended in China a few
uh-huh.
years ago and the executive order,
Yeah.
I get your point that maybe in enforcement they
Mhm.
might be different right now, but as
Mhm.
they're written,
Right.
there are some similarities.
Yeah, yeah. I think, of course, some companies decided to quit China. I think Gallup, right? Gallup is an example. A survey company decided that it's a huge impact on their business model, so they decided to quit. And I think, of course, there are other companies who quit, but I think it's similar logic. You have to revisit your business model to see if it still works, right,
Yeah.
under this new regulatory regime. If the answer
So
is yes, right, go ahead.
the answer is yes.
Yeah. If the answer is yes, and you can still pass the cost benefit analysis of compliance, then you can stay put. Right? If you can't, then you have to think about the spin off or shut down your shop. I think at the end of the day, it's a similar business decision.
Yeah. Well, good. Um, well, great. Look, I appreciate it. It's lovely seeing you. I hope next time you come, uh, please reach out. I'll do the same. But
For
thanks so
sure.
much for your time.
Of course, also let us know when you visit China, and we'll make sure you have all the right apps on your phone and can get around more easily than last time.
No, yeah, no doubt. All right. Thanks so much. Thank you for listening. If you like the episode, if you like the podcast, please share. We do it as much for educational purposes as we do for industry networking purposes around cybersecurity, risk management, and financial crimes compliance. Very much appreciate your support. Thank you again.